Thank you, Kim, and I'll repeat what has been said already, but I believe is worth mentioning once more, and that is that personally, and I believe I speak for the group when I say how grateful we are for your leadership and for the hospitality of the entire North Dakota delegation. So far, I've had a wonderful time. This is my first time in the state, as is the case for many of us, and I'm delighted to be here. And I want to acknowledge your leadership in bringing us together to discuss this subject today, which we're going to talk about solutions from the states. Before I do that, I do want to also acknowledge two colleagues, Secretaries of State, who are here with us, who have provided tremendous leadership to the National Association of Secretaries of State. And one of them is your very own, the very distinguished Secretary of State, Al Jaeger, here from North Dakota. And Al, if you will stand. Al is one of the longest-serving Secretaries of State, having served already for, 16 years, and we appreciate that. And I'm also delighted to have with us my dear friend, Montana Secretary of State, Brad Johnson, who is also a leader within the National Association of Secretaries of State. When we began the discussion a few years back under the leadership of both Kim and Kentucky Chief Justice Lambert on the issue of the need to have dialogue on interbranch relations and how we would get to the point where we understood better the separation of powers, but more importantly, how do we work together. One of the things that I mentioned at that time to Kim, this must have been back in 2005, 2006, is that Pennsyvlania has already in place a model of interbranch collaboration that is set as a standing permanent commission that has been in place since 2005. And I thought that that model, and we believe that it's the first of its type that is addressing issues specifically of inequities in the judicial system, in the legal system. I brought that about, and I'm glad that to have the opportunity to present what we are doing in Pennsyvlania, because I am very proud of the work that we have performed thus far. I have a number of slides, so I'll go through those slides fairly quickly. If you're interested in this presentation, I believe it will be posted in the CSG's website, but you're also welcome to contact me and I'll see that you get it. There are on your tables reports that the Commission, the Interbranch Commission, has issued in Pennsyvlania, and I'll talk more about those as we move along. By way of background, this commission that I'm speaking about, and by the way, has a very long title, and we make sure that if you get appointed to this commission, you have to memorize the whole darn thing, is the Pennsyvlania Interbranch Commission for Gender, Racial, and Ethnic Fairness. And we do hang on to each and one of those words and take our charge very seriously. But this commission is the result of a 1999 committee that was established by the Supreme Court, more specifically the Chief Justice at the time, Chief Justice Flaherty, who said there are issues. We know that within our judicial system there are issues of bias. There might be issues of inequalities that we need to address. So the Chief Justice issued a charge and created a committee to look into issues of bias in the justice system as it relates to gender and race. And that committee met for a number of years. I was a member of the subcommittee that looked into racial and ethnic bias. And in 2003, the committee issued, that early committee issued a report that is known as the final report of the Supreme Court Committee on Gender and Racial Bias in the Justice System. And that report that was divided into 14 chapters consisted of 173 recommendations. And one of the most important recommendations that was made out of that committee report was that please don't let this valuable tool, this report, sit on a shelf collecting dust and be one of many reports that get prepared and issued and you do nothing with it. They're very significant, substantive recommendations that, if adopted, and some were more ambitious than others, if adopted, they can create a more fair and system for dispensing good and fair, equal justice. So with that in mind, the Supreme Court followed on that initial recommendation of creating a permanent standing commission, and that's where we get to this Interbranch Commission for Gender, Racial, and Ethnic Fairness that began meeting in 2005. And why did, even though it was dealing mostly with issues of the judicial system, why did you need to bring the other two branches to the table? And the previous panel very eloquently stated the fact that when you're looking at, in our case, legal issues, you need to have the three branches, because first you're going to need the legislative branch to enact the law that oftentimes is necessary to affect the change that the recommendations call for. Then you need to have the executive branch in place, because the executive branch is going to implement and enforce those laws. And ultimately, you need the judicial branch, because you're going to have, they need eventually to have someone interpret those laws. So with that in mind, the commission was created, and the charge was to bring together 24 members, 8 named by each of the three branches, each branch 8 members, not necessarily legislators or executive or judges, but in fact did consist a good number of members of the three branches. Out of 24, when we first met, 21 had legal training, were lawyers by training, which was very helpful. And we sought to increase diversity, to send a strong message that diversity, being one of the recommendations of the previous committee report, that we need to be diverse in our composition, and in fact it is. Again, the mission of this commission is to implement recommendations, and we broke down those 14 chapters of the committee report 2003 in 6 areas, which are represented by the 6 first bullets that you see here: the interpreter services, grievance procedure, core employment and appointments, jury selection, criminal justice, domestic violence, and sexual assault. We added later in the report the issue of gay, lesbian, bisexual, and transgender rights, because even though it was not directly spoken of in the report, there was a footnote in the report, in the committee report, that acknowledged that there are in fact issues of fairness and inequalities that apply to that community, which is often referred to as GLBT. So that committee was created subsequent to the 2005 first meeting. What I'm going to do, there's plenty of information here. I'm not going to read everything that is up on the screen, but just give you a flavor for what this Interbranch Commission has been able to achieve thus far. And remember, we've been in place since 2005, so we've been operating for 3 years now. And again, I'm very proud of the substantive result that we have had. For one thing, the charge of the Interpreter Services Committee is to address the issue of litigants of limited English proficiency. Pennsylvania, as I imagine is the case in each of your states, is seeing a growth in the number of new residents who are not native language speakers. And regardless of how you feel about the issue of immigration, the fact is that when you are in a court setting, you must find a way to get to the facts and dispense justice. And you don't want to have obstacles of language be a barrier to you being able, as you're a judge, to issue a fair decision. One of the things we needed to do was to first get a sense as to the state of interpreter services within the Commonwealth, and the recommendation was not only to address the courts as such, but also to look at administrative agencies. So we were able to conduct a survey of administrative agencies in the state, and we were very proud to get 100% response from all 42 agencies that we surveyed to find out where they were. And we found that some agencies were very well on their way to having a good system for interpreter services. Others did nothing. And I'm ashamed to say that the Department of State was not doing a whole lot. In addition to that, we supported legislation that was passed in 2006, a Senate bill that called for a requirement in Pennsylvania courts, including administrative agencies, that we have certified interpreters or otherwise qualified interpreters to serve as interpreters for the courts and administrative hearings, because there was a great deal of disparity among the courts. Philadelphia, for example, has a very well-developed system of interpreters. Last year, they invested, dedicated, spent, depending on how you want to look at it, $1.8 million in interpreter services, very well developed. But many of our other 66 counties don't have anything that remotely resembles that. Sometimes you have issues or situations where you're asking the victim's aggressor interpret for the victim in cases of domestic violence, because that was the only person that could speak the language. Imagine how ridiculous that is. You're in the committee public hearings, we found that that was the case. Or a judge with no ill intent will pull a clerical person or the janitor who happened to have the last name Rivera, and the judge thinks that person speaks Spanish, bring in and interpret in the matter of legal issues that I can tell you as a native speaker I wouldn't even dare to try to interpret in a legal setting. But anyhow, we were able to get the Senate to pass, to put forth a bill that required certified interpreters. And this is in the midst, think of 2006, in the midst of the whole immigration debate. We were able to have all 50 members of the Senate, all 203 members of the House pass this bill unanimously, and was signed by the governor, and is already law in Pennsylvania. And I'm speaking about this issue a bit longer than perhaps I intended to, but it's something that I think is relevant for us to mention based on the conversation that we had yesterday, especially about whether the judges had the ability to advocate or lobby, and how the canons of conduct for judges many times prevent them from doing that. In Pennsylvania, for example, the Interpreter Services chairperson is a judge from Philadelphia, very talented. But when we were starting to talk about making the rounds with the legislators and try to persuade them to pass this bill, one of the first things she did is she pointed to a 1980 memorandum from the then Chief Justice that said that judges were prohibited from engaging members of the legislature individually and speaking about issues unless they had the permission from the Chief Justice. So we talked yesterday about the different models and what prevents some members of the judicial branch from engaging in discussions with their counterparts in the legislative branch, and that's where we found ourselves. But then the Chief Justice that we had in the at the time that the commission was formed said, no, you can engage in discussions that are to educate. And there's a fine line between lobbying and educating, so we educate. But we were able to successfully do that. Let me also mention the fact that for this commission to be taken seriously, is brand new, first of its kind. We had to have all three branches fully vested, and the governor came with a very strong message about the worth of this commission. So did the Chief Justice and the leadership in the House and Senate. More importantly, the Supreme Court Chief Justice was the first chairperson of this commission for the first year, and that was a strong statement that this was important to him and to the courts. We have also done other collaboration with other agencies. The next chart just gives you a sense of the prevalence of limited English proficiency in the state of Pennsylvania, where you have more than 8%. These are statistics from the 2000 census that show that more than 8% of people in the Commonwealth have very limited English proficiency. The next committee I'll give you a flavor for is the Grievance Process Committee. And this committee is focusing on and has already drafted new Pennsylvania Unified Judicial System policies and procedures, complaint procedures, to ensure equal employment opportunities in the courts. And I'm glad to say that new policies were implemented, were adopted by the court in 2007. The committee is also working on proposed amendments to the existing codes of conduct for attorneys and judges that specifically prohibit discriminatory conduct in the courts. They're also working on guidelines, like editing a guidebook for judges and for attorneys and court personnel on how to avoid engaging in biased behavior. The Court Employment and Appointments Committee put together, it says here updated, but in fact they created and now has been updated, a recruitment manual, a diversity recruitment manual that includes publications that focus on, say, the Latino community, Asian community, and others, to better have a sense as to where you can go to recruit the talent that you need for the courts at all levels. In the case of Pennsylvania, our judges are elected, or they may be appointed by the governor if you have a vacancy. But for all other court personnel, the administrators, the support staff, we saw that we have, while we have a state that continues to be diverse, we don't have that much diversity in the court. So there is a manual that is giving the courts a tool set to do the recruitment, because oftentimes what we learned from the counties was that, well, we don't have anyone in the court that is of a given ethnic background because we don't know how to find that talent. So we're saying, okay, this is the tool that you need. And we're also conducting training. Jury selection, this is another area where I'm very proud, because we saw, and once you see one of our reports here, we have an illustration. I think I'm very visual, so I found this illustration particularly helpful. And it's about showing that the jury pool, how it shrinks to the point that when you eventually, get to the actual juries that have been that are seated, and it's in the second report of 2006, the one that looks like this. It has this chart that tells you first, when you start in the Pennsylvania system to look at jury pools, first of all, our population is about 85% white Caucasian. And then you look at where the source of the jury list or the jury comes from, which prior to the work of this commission was only coming from voter rolls or the Department of Motor Vehicle driver's license. You see that continues to shrink. So by the time you actually have a case that is being heard by a jury, you may have just one, if any, individuals that may resemble the parties that are before the court. This committee was able to work with the General Assembly to have a bill that was passed and signed by the governor that extends the sources for the jury pool to also include records from the Department of Revenue for tax returns, income tax returns, as well as individuals who receive public assistance. And that is already increasing the people that you see. Some of these graphics, this is just to give you a sense of, this is in terms of the judiciary in Pennsylvania, giving you a flavor for how many female judges versus male judges we have, with the female being the blue and the male judges being is the gray, for all counties, and then all counties minus Philadelphia. The Criminal Justice Committee is looking at several issues, and one of them is how do we increase the number of public defenders, district attorneys, and legal service lawyers. That's always a constant complaint. Not enough public defenders. Not enough talented public defenders. And part of that is because when we come out of law school, many of us come out with high debt. And when you have jobs that start paying only $30,000, $40,000, people cannot make ends meet with those salaries. So where we are is working in collaboration with the Pennsylvania Bar to establish a loan forgiveness program for public defenders and others. And we're working also, another area that we're looking at is expunging records of minors that had any type of criminal record as a minor, and how we go about erasing those records, understanding that expunging the records is difficult. And unless you have clear guidance on how to do that, many of the youth that we see with criminal records, once we become adults, those records sometimes are still available and prevent those individuals from gaining employment, from getting financial aid for college, perhaps getting into the military, and so forth and so on. This is yesterday. I threw this in because there was a discussion about the prisons and sentencing, and just to give you a flavor about the state of the prisons in Pennsylvania. As I mentioned, in fact, this shows that the top pie chart shows that 88% of the population in Pennsylvania is white, Caucasian. When you look at the inmates who are incarcerated in our state prisons, you see that 66% I frame differently, only 34% are white and 66% are inmates of color. Domestic violence and sexual assault, this is an area that many of our members have a very strong interest and passion, and various things that we have done is the creation of manuals and guides for tips that sexual abuse and domestic violence victims can utilize to assist them with just getting basic information that many of us take for granted, but it's not readily available to everybody. And we have found that police departments particularly are very interested in handing out these pamphlets when they go for calls of domestic abuse. And in fact, we also have placed those pamphlets in the latest restrooms at our visitors' stops along the highways, so that people have information readily available. And the committee is also heavily engaged in doing training in cultural considerations in cases of domestic violence. There is a difference between domestic violence and how the victims approach that, and their willingness to come forth with a complaint if you are Islamic versus Hispanic versus other ethnic groups. This is a chart that shows the incident of domestic violence in Pennsylvania. It shows you the total amount of incidents of violence that we believe takes place in Pennsylvania on an annual basis, and only about half of those victims request orders from the courts for protection from abuse orders. And so there is a systemic problem that we're trying to address. And then I mentioned GLBT issues, and the focus right now has been on second parent adoptions. Second parent adoptions, and I don't know how many of you know what that is. I admit that I didn't know when it was first brought about. Again, a recognition that there's some issues of justice and interaction with the courts that do affect, in a disproportionate way, individuals who are gay, lesbian, bisexual, or transgender. But as it relates specifically to second parent adoptions, the issue here is you have a parent, so someone who has a child, and that person's partner happens to be a person of the same sex, and how that partner ends up adopting that child. And there's a lot of complexities in this, so the committee is working on recommendations, and we believe that good progress will be made. As I mentioned, on your tables you will see that we have the 2 annual reports that have been issued thus far. They contain a lot more information than what I have presented in terms of the genesis, the foundation for the work that we're doing, and the results that we have accomplished. We issue a 2005 report in 2006, and a 2006 report issued last year. These are calendar year reports, and we're in the process of now developing the 2007 report that should be out in a few weeks. So in conclusion, what we have found with our work is that we are, again, very proud of the progress that we've made in such a short time. Out of the 173 recommendations, I believe we have already implemented at least 20. But there's the so-called low-hanging fruits. There's some that are very ambitious, and we hope one day to get there. There are many challenges. The Chief Justice, again, being the first chairperson of that commission, sent a very strong message. We get great response from the judicial districts when it comes to any surveys, anything that we're asking from the courts, because the Chief Justice is saying you have to do it. However, Chief Justice Ralph Cappy, who was the chairperson of this commission, retired last year. We have a new Chief Justice who is equally committed. His name is Ronald Castile, a great man. And we no longer have the Chief Justice as a chairperson, but we still have, I believe, the credibility, and we're building that among the 3 branches. And we, again, as I mentioned, that firm commitment from the top is essential. I put in here the contact information for our day-to-day administrator. And this is serious business, and not only do we have 24 members who are volunteers and don't get paid, we don't get paid for the work that we do. And I may have failed to mention that I'm part of those 24 members. But we have an office that's established with day-to-day administrators. So we have an executive director, paralegal, a research person, and the name of the executive director is Lisette McCormick, and there's her contact information. She'll be more than happy to share our experience. We're finding ourselves called upon to share our experience with other jurisdictions, and we'll be more than happy to tell you what we've done, what are some of the trappings, and share with you whatever information that you may deem helpful. And then I put my contact information here at the end. Thank you so much.
Well, as Senator Koppelman said yesterday, the easy part was... Okay. How's this? Is that better? Okay. As Senator Koppelman said yesterday, the easy part was pointing out the obstacles. The hard part is trying to not only point out, but to implement the solutions. So what I'm going to try to do in the next few minutes is to point out some of the general parameters that I think that we need to keep in mind, and then to end up with trying to give you some specific things that I think, in looking at my own experiences and looking at what some of the other states and some of the information I've gained here this week, that we might be able to use, if you're not already using those in your states, to improve interbranch relationships. As Kim pointed out, I've served in the legislature and on the courts. I've been, as you mentioned, 18 years in the legislature and now 10 years on the appellate court. And also during that career before the court, I was on numerous boards and commissions from the executive branch, and I was county attorney for 24 years. So I've got kind of a broad background, and it's interesting, and as Secretary Festa pointed out yesterday, it's surprising when you go from one branch to another branch as to the misunderstanding that exists between the branches and the members of each. I guess Judge Knudsen from Minnesota is maybe the only other one that has legislative and now is on the judicial in the judicial arena. He's a district court judge in Minnesota. Anybody else have joint? Okay. Well, let me just start out by mentioning kind of the roles that we look at. And I think legislators perceive themselves as representatives of the people. And the executive branch perceives itself as the leadership for the people. And the judicial branch probably perceives itself as the protector of the people. And I think within those roles, that's what makes this whole interbranch relationships so interesting and somewhat so difficult in how we deal with it. I want to kind of start out with an analysis that your former panelist, Judge Caparella, used in his material, his law review article that he passed out to you, in which he ends up by saying, yet too often it seems we move on in proud isolation. And I think that that's probably how we tend to operate. Not that we should operate that way, and maybe we'll try to figure out some things that can help us get to a kind of a different perspective. When I was asked to do this program, I called a friend of mine who used to be the administrative officer of courts in North Carolina and who's now a professor at the School of Government and deals with the judicial branch quite a bit, but in his role as administrative officer of the courts, he was obviously over in the legislature quite a bit, explaining to the legislature and dealing with matters that affected the courts. He also was counsel to the Courts Commission, which I had the pleasure of chairing and serve now on, and we'll talk about in a few moments. But he had some interesting observations that I would kind of share with you to start out to kind of the general parameters. he said that in dealing with each other, with each other's branches, we must use self-restraint and respect of each branch. And I think we would all say, well, that's just a given, but it's probably not how we always act. And then he said we must intrude as little as possible. He talked about cooperative collaboration and building trust. And then when one branch deals with another branch, it's intrusion, or at least it's perceived intrusion, it's not as bad. And I would suggest that we would all think that some tension between the branches is good and healthy and a necessary part of that separation. And I would also speculate that the analysis of the statute and the court's interpretation, and sometimes even holding unconstitutional a statute such as we were dealing with today, gets perceived as some slight intrusion, but doesn't cause a lot of conflict between the legislature and the judiciary. But those items that somebody mentioned, I think, yesterday, are some of the things that cause the real conflict and which is perceived as intrusion, such as when the courts step into how you run your educational system, budgetary matters, or as in our state, when it held certain taxes were unconstitutional, and it took away about $1 billion from the General Assembly that they had to come up with. And then as to qualification of members, and then probably something that is just a little dear to legislators' hearts, a thing called redistricting. And so when you get those things going, then you have some real conflicts. And I think we've seen that in some of the states. We saw that particularly in my state. I think when I got on this task force, Kim, I looked around, and just from what I was hearing, and I could be wrong, Kentucky, and Dan, I guess maybe has alluded a little bit to that, has had some interbranch tension between the judiciary and the legislature. North Carolina has. It's improved, but a couple of years ago, the legislature would not even let the Chief Justice come and give the State of the Judiciary speech. So it's changed some. We have a new Chief Justice and some other factors that interplay there that's improved the relationship. But and then if you look at some of the states that have the best relationships, I guess you could look at, and obviously it sounds like North Dakota does, and I don't know if that's just because of the building or not, but I wrote down that one of the possible solutions is put everybody in one building. It seems to work here in North Dakota. But South Carolina and Virginia probably have pretty good relationships with their judiciary and their legislature, and that's because the legislature elects the judges. So their relationship is pretty good. One of the things I also wrote down that might improve relations between the legislators and the judiciary is to have more legislators who are judges. As you can tell, there are not that many who have moved from the legislature to the judiciary. So it gives you a different perspective. And at the last panel, I was sitting here, and Bart would say something, and I would go. And then Judge Koppelman would point out something, and I would agree with that, and you don't get really aggressively agreeing, you agree. There's a different approach between how you act as a legislator and how you see things as a judge. And I think that's something that we have to understand. As a legislator, I really had no restrictions on how I could operate and do things. You can be a passionate advocate on any issue you want to. You go out and you raise money for elections. You help people. That was part of being a legislator. You could help people. Well, you help people as a judge, and you'll find yourself being censored or removed from office. You can't do that. It's a totally different perspective. And I guess the pace is different, too. Legislative pace is much, much quicker than the pace of a judge. Judges have got to be impartial deciders of issues and conflicts. Can't raise money. We must be deliberative, or should be, and we're bound by precedent. And that's something else that sometimes most people don't really understand, that our personal views should not affect how we decide cases, that we decide cases on precedent. But, so Bart, by the way, you might decide that you want to try your talents over in the judiciary sometime. And but I'm not sure, Bart, you may have to change your style just a little bit if you go over to the judiciary. Bart and I have been good friends for a number of years. But there's some other things. The legislatures are changing, and as has been mentioned, it used to be you had a lot of lawyers, a lot of experience in the legislature. Now, in a lot of states, there's not many lawyers who are familiar with the court system. There's not a lot of legislative experience since we have term limits. So that's affecting, and something that Jim Drennan had pointed out. And he mentioned understanding each other. Understanding each other. And that's probably the hardest thing that we have to do. And I'm going to give you some ideas of what I hope will help in how we understand each other's roles and how we operate. Another thing he mentioned that judges probably don't really think about, but that court personnel don't really have knowledge of the legislative system. Courts have to understand that we are strange animals to the legislature and to the public. We operate a lot of times in secret, much more so than the legislative body. And Professor Drennan was suggesting that we need, Pedro, that we need to open up the court process, especially when we say open up, we're really talking about the administrative, procedural part of the courts, not when we're actually deciding the case. But we do a lot of things in secret that nobody's involved in that really we should have public involvement. And so we've got to open up the courts, he suggests, if we're going to understand each other and if we're going to educate each other. Now, what are some of the things that states use in trying to bring about some solutions? One of the things that I mentioned, and a lot of states have, state of the judiciary. Lots of states use the Chief Justice to come to the legislature and give a state of judiciary speech. And I think obviously that's helpful. But I think if that's isolated and about the only thing that's done, then there's probably potential there for improvement in legislative and judicial relations. And a lot of what I talk about is legislative, judicial, and it would apply probably in most cases to executive judicial. A lot of states, and I suspect your state, uses a legislative liaison, governmental affairs office, which can be sometimes, and probably usually is, the administrative officer of the courts plays that role. I would suggest that it's a very, very important role. I would suggest that even sometimes you might want to consider having a legislator, a former legislator, not a current legislator obviously, but somebody who has legislative experience in dealing in that position with the legislature. It doesn't have to be the administrative officer of the courts, but someone also who goes to the legislature and tries to explain, because I think if you understand how that body operates, you're going to be more successful in dealing with it. And these are some of the formal things that I'm pointing out. And I would suggest that legislators and the public perceive the courts as one big cooperative body. And those of us who are involved in the courts probably understand that that's not exactly how the courts operate when you have all these independently elected parts of the court system. From the clerk of courts, who probably in most states, if you have it like our state, are probably the most powerful part of the court system. And then when you go to the district court judges and the superior court judges and the appellate judges and the bench bar committees and the others, and what can happen is that they can all operate sort of independently, and they're looking after their particular issues and agenda as opposed to the overall court system. I remember being in a seminar and talking to someone about how salaries of judges and budgets of the courts. And that particular person from a state, who was a Midwestern state, said, we don't have a problem getting adequate budgets and adequate salaries for the courts. And I was intrigued. I said, what do? He says, well, all of the court personnel and all of the bar associations, whether it be the bar association, the women attorneys, the trial attorneys, the black lawyers association, all of them have gotten together and have agreed that their number one priority and agenda item each legislative session will not be their own individual agenda, but will be adequate funding and salaries for the courts. And he said, we just don't have a problem. But I don't know how many other states have been able to accomplish that, but I would suggest, if you can, you're a long way towards having improved relations between the legislature and the judiciary, because a lot of the items that we have that cause conflicts deal with budgets and salaries and matters such as that. But we've got to find ways to understand and educate each other. And by the ways, the district attorneys come in and the public defenders come in, and maybe they're not a part of the judiciary, but they're certainly a part of the judicial system, and so they have their own agendas. So I would suggest that it's helpful if you can get everybody together to at least support the broad agenda. But with independently elected officials, you know how difficult sometimes that can be. And there's other things. Legislators use physical notes to say how the particular legislation is going to affect the courts as far as monetarily and when they're providing additional personnel and things like that. But another thing that some states may not use is what's called judicial impact statements. It's not just how your particular legislation providing personnel, how much that's going to cost, but it's looking at items and looking at specific legislation that puts additional responsibility on the courts and how that's going to affect the courts. So that, because a lot of times, and when I was in the legislature, I'd pass things all the time, really that would put a burden on the courts and never think about, with everything else they're over there doing, how it's going to impact them. So judicial impact statements, I think, can have a bearing on trying to improve cooperation between the branches and hopefully head off some of the potential conflicts. Joint task force, and that you've heard Secretary Cortés talking about one particular joint task force in his state that's been particularly successful, and I think other states have good examples of that also. One thing I learned in the legislature and heading up a couple of commissions and had it pointed out to me one day, if you want to get something passed in the legislature, when you do a blue ribbon study commission or some kind of task force or commission, if you want to get it implemented in the way that you would recommend, you better have some legislators on there. Because if you don't have the buy-in, you've got a very difficult thing to do when you try to pass legislation. We had a wonderful blue ribbon commission headed by a very dedicated public servant, head of a bank, several years ago in North Carolina, and they recommended some outstanding things to improve the court system. There was not any legislators on that commission, I don't think. And so one of the things they did in that recommendation was they put in to take away electing the clerks of court and appoint the clerks of court. And so that agenda from that well thought out commission was really hampered in its being implemented. It started out with that, and that's all everybody talked about. And they tried to get rid of that and back off of it and say, hey, cut that out. But the damage was done. And I suspect if they'd had some legislators on there, they would have cautioned them about putting some kind of recommendation in there like that would get the report in trouble. So I think, and that's why I would come to mention to you the Courts Commission. that North Carolina has used, and we put some handouts up there. It's pretty simple legislation. When I got to the legislature, I was put on that commission, and we had an outstanding chairman I served under. And we really, it's a commission that I think its strength is by who appoints it and who's on it. And it's really a 28-member commission with 3 ex officio members. And that commission is 8 of them each branch, the Chief Justice, the Governor, President Pro Tem of the Senate, and the Speaker appoint those individuals. And they're specified individuals. And the task is to make recommendations concerning and to improve our court system in North Carolina. So there's one from each part of the judiciary on there, as well as the DA and the public defender and the magistrates. But the key is, I think, having 9 legislators, and it's set out that they, since it was ineffective for a little while. And then I got interested in it and got it reorganized and served as chairman for a number of years until I went on the court. And then we were inactive for a while due to some, just not politics, but just some timing and some membership matters dealing with the chairmanship. But it's been reorganized now, so it's back in effect. But I would suggest to you that that's an excellent way to analyze needs of your courts and have legislative involvement and understanding. And it's the only statutory commission in North Carolina that has legislators on it as well as judicial officials. We have a judicial council, but they're not legislators on it. So they deal with more internal things just with the court system. So I would suggest to you that you look at something like that. I think it has the potential to do a lot, not just in a formal sense, but in an informal sense of dealing and being around each other. And any time you can have legislators and judicial officials around each other, talking to each other, networking with each other, I think it's a plus. And that gets to some other things like orientations. We don't understand each other, and I think it's been mentioned, is we've got to orientate the new members, and not just the new members sometimes. Some of the older members get busy and forget what it's all about sometimes too. So I would suggest that orientation and continuous education of some form, anything that you can do to educate people about the differences. A lot of legislators don't understand that judges have this code of professional conduct and precedent and how they have to decide cases. Bench bar committees are another effective tool, I think, that a lot of states use, and I've served on that in my state. I think I'm going to go back and make a recommendation, because right now we've got a wonderful committee, and we're working on trying to implement in North Carolina this Citizens Salary Commission, which I've become a big fan of since I heard about it from Mary McQueen, because I think it has a way of relieving tension, and that tension is between the legislative and judicial branches over salaries. The legislature in North Carolina hadn't had a salary increase in 16 years. So they sometimes are not as willing to give judicial salary increases when they're making less than $14,000 and judges making $120,000, and they got a 2-year term and judges got 8-year terms. They say, what do you complain about? So this Citizens Commission idea that takes that out of the legislative arena to an extent, and you don't have to have it exactly like the Washington State model. You may not have or need or want a referendum the process, but you can do it through other means. And in North Carolina, looking at it, and I don't think, I know, at least for this session, it won't be a constitutional amendment. It will be statutory. But there are ways and there are things that we can do to be involved with each other and to cut out some of these conflicts. Workshops. I think this meeting is a wonderful way to improve interbranch relationships. I think there's more judicial officials at this meeting than any other interbranch meeting that I've ever been to or heard about. Judges tend to stay by themselves and they go to their own conferences and things. So that's been one of the main focuses of this task force, is to try to bring the judicial branch into CSG, which does deal with all three branches, to try to help us. As Kim said, it's the one branch that has it's the one organization that has all three organizations, which we can bring each other together. So anytime such conferences, and of course this council has the Justice Center, which has been mentioned and is relied on by legislators and judges and executive branch officials. Another way is what's called a day on the bench, or I would suggest it shouldn't be just a day on the bench for the legislator to come and be with the judge for a half day or a day, but the judge ought to go over and follow a legislator around for a day. It's a different experience, and see what they're dealing with. And so, or sometimes it's called a ride-along experience. So I think those are some of the things that may be of use. I think if you can change the structure, and this is always hard to do, and judges are very uncomfortable dealing with partisan matters, even though we are, to a degree, involved in the partisan political process. That's changing some, and in North Carolina it's changed. We've been trying to change our the way we select judges, as a lot of states have. We still elect all of our judges. We've been trying to move to an appointment, or at least a confirmation after an election system. Haven't been able to do that yet, but we did change, and we went from partisan to nonpartisan, and that's made a tremendous impact on our judicial system. And I think it will help improve tensions or reduce tensions between the branches as that goes on. It's just been in effect for a couple of years. We also have public campaign financing, and that's helped, and I've run both ways, and so that's helping to take away some of the partisanship that can lead to tensions among the branches. So there's a lot of other informal ways. Maryland, I think I heard at a conference one time, uses regional meetings between the legislators and judges. But yet we tend, as judges, we tend to refrain from socializing or contacting, except maybe if one comes by the courthouse to talk to a legislator. I think that certainly there are ways to improve those networking and relationships in a social atmosphere that can improve relations and work to diffuse tensions when they get to be conflicts. The Alabama approach is unique. I haven't heard of that before. The governor and legislators we'd meet all the time. But I think that the idea of the Chief Justice and the governor and the legislative leaders getting together on a periodic or some kind of at least a basis where they meet and talk about issues is certainly an approach that could be looked at, because that almost guarantees you have accessibility, and if you got accessibility, you've got a way to reach understandings. But all of these, I think, are things that I would point out are ways that maybe we can come up with approaches so that we don't just walk around in proud isolation, as I mentioned the quote when I started out, and that hopefully we can get to some kind of an atmosphere where we have cooperative collaboration and trust among the branches.
On a hot summer day in the South, it might have been one of the states that's represented here, maybe North Carolina or Kentucky or perhaps Texas. A couple of friends got together on a big old front porch in a country house to chat one afternoon. It was very warm, and they were drinking lemonade, and as they talked, the visitor noticed that the homeowner's dog was laying off in the corner of the porch, and the reason he noticed is he let out this blood-curdling howl, and he didn't want to be impolite, he didn't want to say much, so they continued visiting, and a little while later the dog howled again. And finally, after this happened 3 or 4 times, the fellow turned to his host and said, "Well, what's wrong with your dog?" And he said, "Well, he's laying on a nail." And he said, "Well, why doesn't he move?" He said, "Well, it hurts bad enough to complain about it. It doesn't hurt bad enough to do anything about it." I think that's the way we are sometimes about some of these interbranch concerns. And one of our hopes here is not just to complain about it, which we've spent a fair amount of time doing over the last day or so, but our hope today is to kind of turn that corner and start talking about some solutions. Our panel has been tasked with, as it's been described, the more difficult task of beginning to do that. Now, I want to make a couple of things clear. I'm not a lawyer. I don't play one on TV. I tell my lawyer friends I don't try to apply the law. I don't try to interpret the law. I make the law. I'm a legislator, which puts us in a unique position. But we do approach that task from a very heartfelt desire to serve the people who elect us. We are people of the people. We are men and women of the people. We are the people that are elected, that, as some have described, are closest to the people. We have the pulse of what's going on in our communities, in our states, in our society, perhaps. And we try to bring those things to bear on public policy. And that's really where lawmaking comes from. Once we're done with it, the mess that we leave sometimes is what we heard about in the last session that the rest of the branches have to deal with. So I think it's instructive for us not to just talk about problems, but how do we solve them? Well, let me share real quickly a case study with you that we experienced in North Dakota that I think demonstrates realizing a problem, recognizing it, and then trying to do something constructive about it. And that's a process that I was involved in personally, and that's why it's close or near and dear to my heart, dealing with the executive branch of government and the legislative branch of government, dealing with what are called administrative rules. And for those of you who might be as naive as I was as a layman, and I doubt there are many in this room that fit that description, I didn't really know how administrative rules worked before I came to the legislature. I used to hear this vague term about government rules and regulations and think, oh yeah, they're often bad, because we heard all the horror stories. And I don't think anyone in the legislature really had a problem with agencies of government having policies or procedures or rules to govern how those agencies carried out their duties or how they functioned. I don't think that's a problem. We'd all see that as appropriate. But I'll tell you a quick story about how I learned as a business person in my home community how administrative rules worked. And it was right before I was first elected to the legislature. I happen to be in the advertising business. I own an advertising public relations marketing agency. The truth in advertising laws in North Dakota had been on the books, some written in the 1920s, some others written in the 1950s. They had never had rules attached to them before. But in the infinite wisdom of someone in state government in the 1990s, it was determined that we needed rules to explain what these truth in advertising laws meant. Most of us who were in the business of creating ads and doing advertising, I think, knew the difference between telling the truth and not telling the truth, and so we thought we understood them. But state government didn't agree. There were a sort of a list of rules that were proposed and promulgated by a particular agency of government, and I heard about it through someone I did business with, and they said, you know, this state agency is having hearings over across town today on rules on advertising. I said, well, what's that all about? So I attended. And I was a little bit horrified when I started to look at the language, much as some of you on the court talk about trying to read a statute and say, boy, how do we apply this? It was sort of the same token, being in the business community, trying to figure out how you're going to apply a rule made by a government agency. And the rule went something like this. It said, to demonstrate that you're telling the truth when you're running an ad, you have to have sold a substantial number of that product, whatever that means, at the advertised, the retail price, under a full moon during leap year or some other list of rules and regulations. Well, when you try to apply it from a standard, shirt sleeve approach, what it meant was that if, and there happened to be a clothing store owner in our local community in the room, and I used that as an example as I raised my hand to ask a question. And I said, now I know this gentleman to be an honorable person of integrity, so he would never do this, but suppose he put men's suits on sale, and suppose he said they were 50% off. And suppose he had a college student he hired part-time to work in his store to help work his way through college who was selling those suits. And suppose you came in to do a check to find out under your definition if he was violating the truth in advertising laws. Well, the way the rule was written is literally that college student, in order to tell me when I walked in the door as a customer that suit was on sale for 50% off, would have had to have gone through the books of his employer and determined how many he sold at the retail price for a specific period of time prior to that sale, and then verify that that sale price was actually 50% off. And if he couldn't do that, that college student could be held criminally liable for violating the truth in advertising laws in our state. Now, sounds good on the surface. An attorney might look at that and say, well, it's very reasonable to put some parameters on this and figure out how we're going to enforce this law. But to the layperson, it makes no sense at all. And that's why people scratch their heads and shake their heads and try to figure out how to interpret some of these things. What was also interesting about that process was that I was at a public hearing. The purpose of the public hearing was to get public input. They got plenty of it. The purpose, assumably, of the public input was then to go back and consider it and perhaps change the rule. That part didn't happen. They said, thank you very much for your input. We appreciate it. Have a nice day. And then I asked, well, is there anything else we can do to register our concern? Oh, yeah, you can write a letter. Okay. I wrote a letter. I got a letter back that said, thank you very much for your input. We appreciate it. Have a nice day. And the rule went into place. Now, what is a rule? In North Dakota, and I suspect it's the same in many of your states, administrative rules carry the force and effect of law. So they are just the same thing, basically, as if the legislature came to town and passed a law, and it governs society. It governs whatever regulated community falls under that rule. The frustration from a legislator's perspective is that we're elected to make those laws, and now there's and I think the caricature, and I admit that it's that, in a legislator's mind, is that there is some well-meaning, well-intentioned, but unelected, unaccountable government bureaucrat sitting in an ivory tower someday looking out the window and saying, I think I'll make a law today. Now, they're not elected to do that. There's no one really looking over their shoulder to second-guess them, and they literally have the authority, under the way many administrative rules work, to do so. The problem was, okay, so suppose we get a bad administrative rule, maybe similar to the one that we talked about, and which I just described, which, by the way, the legislature promptly repealed by passing a law to get rid of it. But that was the only mechanism available. There was something called the Administrative Rules Committee in North Dakota, but the people who, I was elected to the legislature not long after that, the people who served on that used to tell me horror stories. They called it a toothless tiger. They said, we come to town, we get a stack of paper this high off the ground called administrative rules. We're supposed to look through that as we come into town for our one-day meeting, and as these agencies parade before us with these administrative rules, and we raise our hand and say, this is really a foolish rule. We don't think this is going to work. Please don't do this to the public. They got the same answer I got. Thank you very much for your input. Have a nice day. And the rule went into effect. So the only recourse from a legislator's perspective was to wait. And in North Dakota, remember, we are very much a citizen legislature, a part-time legislature, to wait perhaps 2 years, as long as 2 years, to come back into town, to draft a bill, to do away with a bad rule. Maybe it would go into effect 6 months later if it went through the process and was signed by the governor and so on. Meanwhile, the citizens we're elected to represent are languishing under that rule for a long period of time. And it wasn't created by anyone they elected to represent them in state government. The authority constitutionally to make law is a legislative authority. And so as legislators, we guard that pretty carefully. And many legislators saw this as a really an unconstitutional, perhaps, or at least ill-advised delegation of legislative authority to a different branch of government, which isn't the lawmaking branch, the executive branch. Now, is that our own fault? Did we do it ourselves? Well, you could argue that we did. But the problem is, how do we fix that? And I said I was going to talk about solutions. I've outlined the problem. When I was elected to the legislature, I drafted a bill to sort of reform the process of government regulations, executive branch government regulations, administrative rules in North Dakota. As a freshman, I think I flew under the radar for a while because I don't think anyone expected senior legislators, most of them much less a freshman coming in off the street, to understand how these rules worked and how we could possibly do anything about them. But I'd studied it long and hard, and I was a green legislator. I thought interbranch was a reality. I didn't know how to do this. So I went to my legislative leadership first, and I said, I'm thinking about this bill to fix administrative rules. Here's my idea. And they said, good idea. And I didn't go to the judiciary because it didn't really apply to them, but I trotted down to the governor's office, and I said, I got this idea. What do you think? And the governor said, you didn't go far enough. You should have thrown out all the administrative rules. I don't think maybe wasn't this governor. He may not want to be quoted on that. But the bottom line was, I tried to vet that idea with different branches. And it really gained a lot of favor going through the House, and then Bart's chamber got a hold of it when it got to the Senate. By then, the executive branch of government, I think, kind of became aware of what was going on, and one of the, I think the chairman of the Senate committee that considered the bill, when the room was packed with state employees from the executive branch and one or two of us there to actually support the bill, asked, as he looked around the room, and you all were in our Capitol, the Capitol Tower where the executive branch leadership is housed, and he said, "Did you all turn the lights off in the tower before you came down here to testify against this bill?" Because it was as if all of that branch of government was there to oppose it. The end of the story was that the bill passed, and let me tell you a little bit about what it did and how I think it is a success story and has changed the way we operate in this arena in North Dakota. We didn't do away with the administrative rules process. We recognize that there's a legitimate role there and so on. And a lot of it was illustrated, frankly, earlier this morning. When we come into town, when you consider how the legislative process works, and we draft a bill, and we try to make them as complete, and I think that's something legislators can learn. I've been told that by many of my friends in the other branches. Please write more specific, more complete laws. Message received. I think we do need to do that. But then when we leave town, sometimes an agency of government that is tasked with implementing that bill we've passed has to figure out how to do it. And sometimes it requires and involves writing administrative rules to do so. But the system had gotten so far out of whack that some would allege, I would never accuse anyone of this, of course, but some had alleged that there were actually agencies of government who would basically float a bill in the legislature, and it would fail, and that same language would turn up in an administrative rule 6 months later. And some would also allege that the attitude in our tower next door, in our beloved sister branch of government, among some at least, was, we know this won't pass the legislature, so let's wait until we see their taillights going over the hill as they leave town, and then we'll make a rule, and it just will be a lot easier. We legislators believe, that needed to be changed. The success story, the good news, is it did change. What happened was we crafted legislation, and I have to give credit to our legislative counsel, our attorneys there, who did wonderful research about what had withstood constitutional muster, what had withstood court challenges in other states and been upheld, and what had not, and we crafted our bill accordingly with those success stories elsewhere. And we basically came up with a provision that allowed the Administrative Rules Committee, which is made up of the legislative branch of government, the lawmaking branch of government, to sort of oversee this administrative rules process, thereby restoring, I think, what the original intent was, which was shared authority and a good check and balance system. Now, I was sentenced to serve on the Administrative Rules Committee after sponsoring that bill, and I've done so ever since. But as we come into town, we have a much different relationship with the executive branch of government than we used to. The old way was this, what I described in the committee hearings, what I described in the legislative process and so on. It was, legislators would come into town, the agencies would trot the rules there, and if they didn't like them too bad, they'd go home and the rule would stay in effect. Now, oftentimes, the heads of those agencies will come down, or people that are very, very well informed and very responsible within those agencies and very involved in that topic area will come down to present, defend, and discuss those particular rules. What the legislation essentially did is it gave the Administrative Rules Committee the authority to void rules under certain parameters, that were upheld by courts in other states. And I don't have the entire laundry list in front of me. I think there were about 6 items. But it are things like if the rules were arbitrary and capricious, we heard that term before earlier this morning, and I know you attorneys know that's a term of art, or if it violated legislative intent, we've heard a little bit about that, if it presented a risk to public health and safety, and so on. There are a few others. So if a legislator on that committee feels that a rule violates some of those parameters and really is not in the spirit of what the legislature intended when they passed that law, or maybe the rule doesn't even apply to a law the legislature passed, that happens often as well, then we have to look at some of these other parameters, then that legislator on the Administrative Rules Committee can move that the rule be voided. If the committee agrees and the rule is voided, then there's another procedure, and the committee can actually consider it at another meeting if it chooses. It can reverse its action, or it can hold it over for later consideration, and so on. I won't go through all the minutiae of the process. But the other very important authority that this legislation gave both the executive branch and the legislative branch is the authority to work together. The executive branch agency can agree with that legislative Administrative Rules Committee to amend a rule that's troublesome. Maybe a rule is 98% just fine, but maybe there's some language in there that really turns the intent of a statute on its head. And the legislature says, look, we can't live with this. This is not what we meant when we passed that bill 6 months ago or 2 years ago. The agency says, oh, well, we misunderstood. You know, we understand. We'll agree with you to change that language to this. Now we understand what you mean. This bill gives us the authority to do that. And I think the process, the outcome, has been very positive for our state because the boogeymen were out there and the horror stories and the prognostications of what might happen if we passed this bill, now about 13 years ago, I guess, that it was passed, were that, oh my goodness, these gunslinging legislators are going to come to town and they're going to tear to shreds every rule we make, and it's just going to be chaos. Well, what happened was, the result is very few rules have been voided because that relationship of mutual trust and respect, mutual authority, was restored. And oftentimes, far more often, do those compromises, and on most of the rules we don't have to do anything because they're just fine. Because agencies understand that the legislative branch, the lawmaking branch of government, has a little bit of authority over the rulemaking process. To me, when we talk about checks and balances, when we talk about integrity, when we talk about mutual trust and respect, I think that greatly illustrates how that process has worked well in North Dakota. Now, would every agency employee in North Dakota tell you they love the change? Maybe not. But I think most actually would, and I think most agency heads would, because we've been able to tweak that in the years since to do some other things that agencies wanted to do. For example, they would say, you know, we've got this voluminous rule on the books, and it's antiquated. We don't use it anymore. It's been there for 25 years, and it's an area of law that doesn't apply for whatever reason. In order to get rid of that rule under the old system, they would have to go through the entire rule promulgation process, have public hearings, et cetera, come back through the whole thing. It would take about 9 months, the way the old system used to work, and cost the agency a lot of money. They said, can't we just get rid of this? It doesn't work. So what they do is now we have a provision where they can bring it before the Administrative Rules Agency, tell us that, or Administrative Rules Committee, tell us that, and we say, okay, we agree, we understand, you don't need it, let's just get rid of it. Made government far more efficient also in some cases. And then we've been able to tweak the process in order to speed it up and sort of compress it a little bit because it was very long, very cumbersome, and very costly. So working with the agencies, they've come to us and said, you know, we know that you've changed this administrative rules process. Here are a few things we see that you could do better. And in recent sessions, we've been able to craft legislation which has continued to work toward that end. So I was asked to share a solution, and I think that's one that I've been involved in that really speaks well about how I think this interbranch cooperation can work when the agencies of government, or the branches of government rather, the executive branch in this case and the legislative branch, but also perhaps with the judiciary. And I could tell you stories there too in North Dakota about court unification and about a public defender system and some things we've done working with the judiciary where they've come to us and said, we've got a problem here, we need to fix it. I think the branches can and should work well together, and that's why we're all here. Thank you very much. I'll put my other hat on to ask if there are any questions. We do have a few minutes before lunch. If there's anything that anybody had comments or questions for the panel on. Senator Hansen.
I'm Tom Hansen, Senator from South Dakota. Tom Hansen, Senator from South Dakota. And this isn't exactly the thrust of this conference, but a question that's been rolling around in my mind all yesterday and today, and I think this is an appropriate time to ask it. Whether or not it's something that can be answered, I don't know. But with regard to the relationship with other governmental entities, especially in the case of the judicial, a little bit ago you mentioned redistricting is one of the things that can cause some contention. And of course, you know, in many instances, or at least in the only instances that I'm familiar with, redistricting has brought in the federal court. And I think that in many instances, the relationship between the judicial and the legislative and executive branch at the state level may be at least reasonably friendly. I don't necessarily get that same impression with regard to the relationship that exists to the federal court system, thinking it's much more adversarial. And of course, then you mentioned the administrative rules. Again, we feel that we're unjustly dealt with often by rulemaking authority of the federal government. And I guess I would be just interested in any comments that anyone or all of you might have with regard to just expanding the question a little bit beyond what I think the original intent of this conference is.
Well, let me address the first part. In North Carolina, our Supreme Court did get involved in redistricting, and it issued a decision, and we have 7 members on the court, and of course we have at that time and still do, a Democratic legislature, controlled legislature, both houses. And of course the opinion was a split decision right along party lines, which caused some consternation. And it went against the redistricting plan that the legislature had put in place. So it caused a great deal of conflict between the legislature and the courts, and cool heads prevailed, but there was discussions about lots of different ways from a budgetary process to get back at that court for that decision. And it's taken a while for that to subside. Fortunately, they didn't do some of the things that they talked about. But that's an issue, I guess anybody that served in the legislature knows, is close to the heart. And then the other items are the budgetary issues, when you lose revenue and it makes you go out and have to cut other services or raise taxes, and that court made you do it, And so, but it's the overall thing. If you're asking about the relationship between the states and the federal judiciary and how it's perceived, yes, I'd say that the perception of the federal judiciary is among legislators and probably a lot of state court officials as well, that there's some concerns, and the relationship is probably not as cooperative, obviously, as it is with the state relationship, because I guess everybody likes to attack that Supreme Court that for whatever it did that somebody doesn't like, but y'all might want to chime in.
Go ahead, Chief.
It is. With regard to the question the Senator just raised, the Conference of Chief Justices has passed a resolution going on record as recommending that the federal courts take a hard look at what they're doing in allowing federal administrative agencies to preempt state law, because it has become a big issue. And so to that extent, at any rate, the Conference of Chief Justices has stepped up, as I think has the National Conference of State Legislatures, and opposed that. It's one thing perhaps to have Congress under their broad powers preempt state law. It's another thing to delegate to a federal administrative agency the authority to do so, and it's becoming boilerplate for those administrative agencies at the federal level to write into their provisions, and all state laws in conflict herewith are hereby preempted, and that's what's going on. So I think we are seeing some support in the federalism issue between the states and the federal government.
Thank you, Mr. Chief Justice. And that really is an issue of federalism, the issue that Senator Hansen raised, and it really is an issue that I think CSG is very concerned about. In fact, we give out an award now, Federalism Award, to people in Washington that do defend states' rights and the authority of states as it was originally intended in our Constitution. So certainly we're supportive of that. CSG maintains a Washington, D.C. office. There are also other legislative organizations that lobby Congress, and certainly I think we could probably put together a whole other conference on that issue, but I think it's certainly something that we should be involved with. One of the things, getting back to administrative rules, that we've done in North Dakota is that the legislature has sort of fired a shot across the bow and said that when federal regulations have no application to the state of North Dakota, as oftentimes they don't, because they're a one-size-fits-all. For example, if our health department is told to promulgate regulations, or our agriculture department, and it includes regulations on how you apply pesticides to the pineapple crop, we say, you know what, we don't grow pineapples in North Dakota, they won't grow here, we're not going to adopt that rule and clutter our administrative code with it and pay the cost for including it. Now, it's never been challenged. I don't know what the legalese of that is, but I think it makes good common sense. Pedro?
No, I was going to add to, it's been said already, interesting how we all picked up on the same words, and the Chief Justice mentioned the conflict and the state rights. And you're right, Kim. I think at some point in time we can put another conference to deal with that vertical relationship between the state and the federal government. You know, this is horizontal across the branches, but we see a great deal of conflict even in our National Association of Secretaries of State when it comes to issues of, you know, the federal preemption in areas of, for say, elections, where we believe the federal government should not be meddling with. But the issue of redistricting, I can tell you that in Pennsylvania is one of the most divisive, just conflicting subjects that we have, because right now the best model that is in the books is a joint commission of both the House and the Senate to do redistricting, but it's viewed as being quite self-serving because ultimately affect the districts at the state level. And I know the governor has proposed a different reorganization of that commission with different members that I think will bring a broader perspective on the subject.
Kim, let me mention two things, and you're right. This federalism thing could and has resulted in a lot of CSG action. I served on a task force several years ago with NCSL. Governor Mike Leavitt from Utah was chairman from CSG side, and we had a co-chairman from NCSL. I've forgotten who it was, but we worked for probably over 2 years trying to do something about federalism and getting attention. And we went to conferences. We held summits, and we did have some impact. That commission is no longer active, but and the courts, the Supreme Court, obviously started issuing some decisions that actually looked at that whole role of federalism, and there were some decisions that came down that were supportive of a more state involvement in this role of federalism. So it's started to slip away again, and it may be time to raise its head. But I would also point out to you something that I found when I was in the legislature, and we had a lot of people come to us and tell us that, well, we're agencies. We're required to do this because of federal regulations. And sometimes if you look behind that, the regulations don't exactly say that. So I've got a bill prepared and passed it that said at any time anybody was bringing forth legislation that was required by the federal government, that they had to include a copy of the regulation that required that, or the statute that required that, and that we had to know the physical impact also of what was required. And we also put in there not just, we made it apply from the state to the locals as well, because the locals said we were putting the federal mandates on them, like we were complaining about the feds.
I think a lot of legislators are taking notes on that one, Judge. That's good.
It's still in existence, but I'm not sure they always pay attention to it.
Imagine that. Thank you very much for your time and attention. We have